Hello, welcome everyone joining us. I'm Sam Clark. I'm from Londisford, England. I am sat watching the numbers zoom up as to who's with us, so I shall wait until we have got to the number of people who've booked on. But hopefully you're seeing the screen and seeing that this is the Mental Capacity and COVID-19 Myth-Busting webinar, and you're in the place you want to be. We'll give everybody another moment to join. Okay, we're getting well onto the number that we're expecting now, so I'm going to start talking about the webinar, just so that you all know. We are recording it, so it will be available to people later, and that's brilliant. We've got some people confirming that they can see us and hear us. That's great. We are going to take questions in the Q&A bit, which hopefully you've all found along the bottom of your screen if you go to the little bit along the bottom. And what's going to happen is the three colleagues from 3906 Chambers, I'm going to hand over to them in a moment, and they are going to try and keep an eye on your questions or issues you raise as we go along, and hopefully then try and answer what they can, either as we go along. If it's very simple, somebody might put a link in or a short answer, but you can also, there's going to be a slot at the end for them to try and answer any questions that can't be done in the chat. So I think we are now a minute past our starting time. Mel, thank you for telling us. The Q&A is at the top of your screen if you're on a tablet. Thank you very much for pointing that out. For everybody who's looking at the bottom of your screen, you might find it at the top. Now, for anybody who can't hear anything, you could be muted. So you need to look either at the top or the bottom of your screen, and there will be a mute button that for you to turn yourself on or off. You aren't going to be able to speak to us today because there are going to be the best part of 500 of us on once we get going. So we couldn't work out how to manage that without asking you all to use the chat. So I think if most of you are all right, then I'm going to stop speaking now, and I'm going to hand over to Alex, Rachel and Steve, who are the three barristers from 3906 Chambers. Thank you very much for doing this webinar about Mental Capacity Act and COVID. And I think I hand over to Rachel first.
Yes, great. Thank you very much. And thank you everybody for coming along virtually. I'm going to start with just a quick overview of the Mental Capacity Act, what it does, and how it works for people who might be a bit less familiar with it. And then Steve and Alex are going to pick up on some specific complexities. So if we could go, Steve, I think has control of the slides. If we could go to the first slide again. I think next. Next, many slides. Great, thank you. This is some key concepts in the Mental Capacity Act, and you see there the first thing it says is statutory principles. The Mental Capacity Act deals with how decisions should be made when people can't make them for themselves, or in the terms of the Act where they lack capacity. And it starts right at the beginning, section 1, with some very important principles. Those are the statutory principles I've referred to there. And those are that you must assume that somebody has capacity unless it can be established that they lack it. Normally that's going to involve medical evidence from somebody who's qualified to comment. Someone's not to be treated as being unable to make a decision unless all practical steps have been taken to help them do so, and that hasn't had any success. The key concept there is of all practicable steps. So it's about thinking of what in practice you could do to help somebody to make a decision for themselves. Would it help if you try different ways of presenting information? Are there particular times of the day where it might be easier for somebody to make a decision? Things like that. All of those things have to be investigated before you can conclude that someone can't make a decision. And another one of the principles is that someone's not to be treated as unable to make a decision because they make an unwise decision. So a foolish decision is still a decision. I suspect many of us have made decisions which might not have been indicated in the course of wisdom or possibly in our own best interest, but that didn't mean that we lacked the ability to make that decision. Then there are two principles which go to, if somebody does lack capacity, how do you go about making that decision? Anything that's done must be done in their best interests. And before you do it, you must think about whether there's an alternative that could be taken instead, which would be less restrictive for them. I'm going to come back in a minute to the other two concepts listed there, mental capacity and best interest, in a bit more detail. But just before I do that, it's also important to flag, as you see at the bottom there, that the scheme of the Act is to enable decisions to be taken on a sort of fairly informal and rolling basis. There's a general authority where the criteria are met to act and to take decisions. It's not everything, not every single decision has to come before the court for authorisation. Although there are categories of decisions which do so, but there are processes which enable decisions to be made without having to seek court authorisation first. Steve, could you go to the next slide, please? So these, just a bit more detail about the key concepts of capacity and best interests, because those are really the keys around which the whole scheme of the Act turns. Capacity is set out there, section 2 and section 3. There are really three questions under section 2. Is someone unable to make a decision? If so, is there an impairment or disturbance of the functioning of their mind or brain? Those are the terms that the Act uses. If there is an impairment or disturbance of functioning, is it because of that that they're unable to make the decision? There has to be that link between the impairment and the inability to make a decision. There has to be a causal connection. There's also some more to section 2 which I haven't copied out there, just in the interests of brevity, including the important and obvious point that lack of capacity, you can't assume a lack of capacity based on assumptions about people, based on their condition or an aspect of the way they're behaving. There are many people who have conditions which mean that they may have an impairment or disturbance of functioning of their brain, but that doesn't mean of itself that they're unable to make a decision. How do you know if they are unable to make a decision? Well, that's where you look at section 3. And that sets out what it means to be unable to make a decision, the key elements of being able to understand the information that you need to make the decision, to retain it, use and weigh it, and then to be able to communicate it as well once you've made it. If somebody does lack capacity, you then go on to think about best interests, but it's important that you only go on to think about best interests if you have established that they lack capacity. If somebody can make a decision for themselves, then the Mental Capacity Act is not going to assist you. Even if that decision is plainly not in their best interests, there's no ability to interfere with it under the Mental Capacity Act if it's a decision that they can properly be said to be making. And it's difficult and important sometimes to be aware of the urge to protect people, to act in their welfare, but it's very important to be alive to the fact that you can't let that urge, creditable as it may be, wag the dog of decision making. It's got to be capacity first, then best interests. in relation to acting in someone's best interests, Section 4 effectively sets out a checklist of the matters which have to be considered. Some of the important ones are set out there on the slide. You also have to take account of any other factors which the person themselves might take into account if they were able to do so. Again, the person themselves, they've got to be permitted and indeed encouraged to participate in the decision as much as possible. And really, decision makers should be putting themselves in that person's shoes. It's not the case that it's automatically what would the person have done for themselves. That's going to be what's in their best interests. But that is always going to be, and rightly should be, a very weighty factor. And it's going to be compelling for the courts to know that. Steve, could I have the next slide, please? Excellent, thank you. In addition to the general, that's the general scheme of capacity and best interests which guides the whole Act, but it also contains some other important provisions. I've set out a couple of them here. So lasting powers of attorney, which many people will be familiar with. Those are, that's the ability of somebody who has capacity to make a decision in advance, giving somebody the ability to make decisions on their behalf, and that power continues to exist if you lose capacity. So if you make a lasting power of attorney, it gives somebody else the ability to make a decision. That could be in relation to your health and welfare, or it could be in relation to property and financial affairs. And it will continue to be the case should you lose capacity, and that anyone who holds a lasting power of attorney in relation to you will have to be consulted in relation to decisions that affect you. There are various formalities that have to be complied with for those to be effective, which includes, importantly, registration with the Office of the Public Guardian, and the Court of Protection has oversight over whether they've been validly completed. It's important to remember that they can only be made by persons who have capacity at the time that they make them. If you've already lost capacity, the court does have powers to appoint deputies instead to exercise similar sorts of powers, but this is you deciding in advance who you would like to be able to have that sort of power. When you're exercising the powers under a lasting power of attorney, obviously that is subject to the general principles that we've discussed and the requirement to act in the person's best interests. There can also be specific restrictions included within them. Another provision under the Act relates to advanced decisions to refuse treatment, which is a decision by an adult that if at some later time a treatment is proposed in relation to them and they can't consent, that treatment is not to be carried out. So, for instance, you could indicate that you don't want to receive a particular treatment if you are in a position where you're not going to be able to make your wishes and feelings heard at that time. Those can be withdrawn or altered at any point whilst you still have capacity. If they relate to life-sustaining treatments, so for instance, decisions around cardiopulmonary resuscitation, then they need to be in writing, they need to be witnessed, and they need a statement to the effect that that decision is to apply even if your life is at risk. The other thing the Mental Capacity Act does, obviously, is provide for oversight by the Court of Protection. And Steve, if you could go this the last slide, that the Court of Protection is a specialist court. It deals with everything within the scope of the Mental Capacity Act. The key things it deals with are set out here. Firstly, determining questions about whether somebody is able to make a decision for themselves. If not, then whether a deputy should be appointed to make that decision for them, or whether the court would just make the decision themselves. Thirdly, to make declarations as to the lawfulness of acts. That's particularly relevant in the context of medical treatment decisions. And fourthly, to hear challenges to DOLS authorisations, so authorisations depriving somebody of their liberty in a care home or in hospital settings. I think that is everything from me in terms of an oversight, so I will hand over now to Alex. And Steve, if you can go through, yeah, thank you very much.
Thanks so much, Rachel. And thanks so much for giving us that overview, because I think it's really important for people who may well be familiar with the broad outlines, but don't necessarily have, they need that little refresher. So can I, my glamorous assistant Steve, have the next slide, please? What I want to be thinking about is, I want to drill down in a little bit more detail into what good looks like against the refresher framework that Rachel's just given you. So I want to think first about capacity assessments, and then want to think about best interest, and then I want to do a bit about advanced care planning. So I'm really thinking here about capacity assessments in the context of COVID-19, because one of the things that COVID-19 is doing is making the Mental Capacity Act, which has not been changed at all, have to be used in circumstances for which it's really challenging to do it. And that you cannot go wrong, you really can't go wrong by always falling back on the principles, always falling back on the capacity principles to start with, that presumption of capacity. Thinking about, does that decision, have I got a reason to think whether or not this person's got capacity to make this decision? If I haven't got a reason to think whether or not that person's got capacity to make the decision, why are you even asking that question? But if you've got reason to wonder whether or not that person's got capacity to make the decision, for instance, to continue living there, or for instance, to abide by the rules under which we're now all obliged to operate in terms of social distancing. If I've got a reason to think that, then at that point, if you're involved in the care of the person, you then need to think, what evidence do I have? How can I assess this person's capacity? And then again, in context of the principles, just reiterating again, the mere fact that the person seems to be taking a decision which is spectacularly unwise doesn't itself mean that they lack capacity. It may be a red flag to ask whether or not they've got capacity, but it doesn't necessarily in and of itself mean they don't. And then that last one, supporting people to take their own decisions. And actually almost one of the wisest things that anyone has said to me about COVID-19 altogether, in terms of just trying to think about this in the big picture, if people need to understand the concept of supported decision-making more broadly, members of the public more broadly, COVID-19 could not have come along and given us a better example. Everybody is trying to work out how to make decisions in completely uncharted territory, with difficult information in stressful circumstances. That's exactly when everybody needs support to make decisions. But someone who might have, for instance, a mild learning disability needs that bit much more support, potentially. But then we're thinking about how we are going to overcome the barriers which have currently been put up to us, if we're having to, for whatever reason, assess the person's capacity. Is the barrier a visiting restriction? So if there's a visiting restriction, for instance, by the care home, a blanket visiting restriction, well, is that, as it were, a legitimate restriction? It may very well be, but if it's not a legitimate restriction, or it's an overly restrictive thing, because, for instance, you are the assessor, and in fact, you know you have had COVID-19, would that alter the circumstances under which it would be acceptable for you to go in and see the person, because you aren't necessarily carrying in the risk of transmitting COVID-19? Because that's one of the important reasons why you wouldn't want additional people going into facilities if there's a risk that they might bring with them COVID-19. So what sort of restrictions are in place? Is it a public health restriction, or is it just an overly restrictive mechanism placed on the care home, for instance, because they're short-staffed? Steve's going to talk about overly restrictive practice later, but I just want to come back just to reiterate here, it's important to think, why is it that I'm not potentially able to do the capacity assessment that I might want to do in the way I might want to do it? Is there a language issue? I mean, it could be, as it were, an English not being a native language issue, but it could just as easily be this person communicates most effectively by Makaton. Well, how, if you're supposed to be potentially, Steve, I think you've got a bit enthusiastic, I'm still on capacity assessments. Do you mind probably just taking the slide back for a second? If we're thinking about having to do remote assessments now, which the Department of Health and Social Care's guidance from last week about mental capacity says should be the norm, that is a big challenge for us. That's a big challenge for people, because normally assessment is meant to be face-to-face, so you can do things like take into account body language, because so much of communication, even with people who communicate by words, is not purely verbal. and the second you then got in place but remote assessment, you're already adding a layer of complexity. So what things can be done to secure as best as possible the effective communication between the person? Technology, well, there's an awful lot of talk about technology, different kinds. One very simple thing I would flag up is that in circumstances where it is being said, you can't, for instance, send in an iPad or a tablet to use because of the risk of infection. There are some really good papers out there. I've linked on my website, which we will show you at the end. I've linked at my website to a really good clinical guide about how you effectively clean an iPad, how you effectively clean a mobile phone. I would say technology is not the solution to everything. It really isn't. But it goes a long way to help in some circumstances. And then also, what does good look like? Well, good looks like recognizing the least worst option. Because things are having to be done at present for legitimate reasons. There are some circumstances where people have gone too far. Steve will talk about that, but many things are having to be done for legitimate reasons, which mean it's not possible to carry out capacity assessments in the way that we as barristers would be advising was necessary just a very few weeks ago. So it's what's the least worst way I can secure a consideration of whether or not this person's got capacity to make this decision. And then documenting how far you've had to deviate from what you know you would want to be doing if you were the capacity assessor. Or if you're not carrying out the capacity assessment, but you're in some way involved, documenting how far things have had to go from what is the ideal. And then that last bullet point on that page, readiness to review. Recognizing that things are having to be done now in this context in terms of thinking about someone's capacity to make relevant decisions, which actually really do badly need to be kept under review. For instance, if and when the social distancing rules get relaxed, because I think what's going to be happening over the next few months, I think everyone thinks there's going to be relaxed, tighten, relaxed, tighten. Well, what about when things are more relaxed so it is possible for a capacity assessment to be carried out under better circumstances? At that point, have to think about review. Because apart from else, that is then complying with the principle of the Act, which says you can't say a person lacks capacity to take a decision unless all practicable steps have been taken to support them. And if you have not been able to take a step that you know ideally should be taken, but is currently impossible, you then have to potentially come back and revisit. So that's capacity assessments. And then do you mind if we just move on to the next slide, Steve, thinking about best interests? So best, starting with the person. Starting with the person, the reason I put up Aintree is the most important case, actually, I think, that the Supreme Court has decided about the Supreme Court, about the Mental Capacity Act. It was a very strange case in some ways, just in terms of how it turned, in terms of the actual hearing, because normally what happens in a court case is the barristers spend ages, this is going to be a technical term, ages rabbiting on with the judges every so often asking questions in a case in that nature. In this case, the barrister for Mrs. James, who was the widow of the man at the heart of the case, which I'll tell you about a little bit more in a second, he got in about a couple of words, and then Lady Hale spent the rest of the day explaining to everyone else in the courtroom what the point of the Mental Capacity Act was. And she really meant it, because she had been in at the beginning, she had been the law commissioner who had had responsibility for what became the Mental Capacity Act. And I remember very vividly from the hearing, her taking a huge amount of explanation to say what the point of it was. Because what the point of the Mental Capacity Act and what the point of the best interest test is, you start with the person. You put yourselves in the shoes of the person. In the Aintree case, what was supposed to be happening was that the court was supposed to be putting itself in the shoes of Mr. James and asking whether he would want life-sustaining treatment to be continued in an intensive care unit, where it was on offer, but the doctors were thinking, this is increasingly unpleasant, increasingly awful. We are very edgy about whether it's really in his best interests. And where the Supreme Court said that the Court of Appeal had gone wrong was they took Mr. James and asked, what would the reasonable person want? The Supreme Court, Lady Hale, said you have to ask, what would this person want? You can't always get what you want in the name of best interests, though, which is the second slide, the second bullet point. It's really important. Best interest is the choice between the options which are actually available to the person. And one of the really awful things at the moment is the options which are currently available to people across the board are being reduced in all sorts of different ways. And because you don't have capacity to make a decision, it doesn't mean that you can't get more. You should not be getting less because you don't have the relevant mental capacity to make that decision to ask for it, but you can't get more. So the best interest is the choice between available options, but good means everybody challenging on behalf of that person what options are being put on the table, what decisions are underpinning, for instance, the decisions being made under the Care Act as to what care is going to be funded. And I would just say that last bullet point, it's not always about money. It's not always about resource. Yes, of course it is. Often, actually, it's inadequate resource being put into things. But actually, some of the things which always strike me so vividly in the work that I do, either in the courtroom or when I'm training or when I'm involved in different circumstances of mental capacity, so often it is about the little things in someone's life that someone isn't actually paying attention to. Where actually, if, for instance, greater effort is put into, for instance, finding the DVDs which the person actually likes at this point, that just makes such an enormous difference. And that's about best interest decision making at the micro level, just as much as it is about the big picture stuff. So then can I just spend a couple of minutes talking about, next slide please, Steve, a couple of minutes talking about deprivation of liberty. I don't want to spend very long talking about it because it's problematic, it's a very big area to talk about. Can you prevent it? Is there anything that can be done to stop the person being confined? So in other words, being prevented from leaving, and if they aren't free to leave, being under continuous supervision and control. Actually, realistically, in many circumstances where someone's got complex care needs, the answer is no. And if they're confined and they can't consent, and if the state knows or ought to know, they are deprived of their liberty. And they're deprived of their liberty whether or not they appear to be compliant with the situation, whether they're acquiescent, even whether they appear to be actively happy. That was the very strong message from Lady Hale in Cheshire West. If you're confined and you can't consent, there is a deprivation of liberty. But what's really important, of course, that means that you then got to get it authorised. And we've got all sorts of problems with the authorisation mechanism, DOLS, the backlogs and things like that, and even more problematic at the moment because of the impact of COVID on people doing assessments, the impact of people on COVID-19 of people doing the work required. But pragmatically, on the ground, working with people, can you minimise the effect? Yes, the person might need to be confined, but are there ways in which you can minimise the impact on them? One really important point I just want to flag and then move on from and show you some guidance at the end. What is the point of the deprivation of liberty? DOLS, deprivation of liberty safeguards, can only be used for the risk of harm to the person. If it is about potentially spreading COVID-19, that is something which DOLS is not designed to cater for. And the Department of Health and Social Care guidance, which came out last week, makes it very clear that is the sort of point where the public health legislation, that's in the Coronavirus Act, and the operation by public health officers of mechanisms to isolate people, that's where that has to be done. I will show you at the end where you can see that in more detail. But just staying with the DHSC guidance for a moment. The DHSC guidance is recognising at the moment it's difficult to carry out assessments, so they're saying remote assessments. They're also recognising that supervisory bodies, local authorities in England and local authorities or local health boards in Wales are having a difficult time doing their jobs. They have said proportionality must be the watchword. One person's proportionality could be another person's licence for not actually doing what they're meant to do. So one of the ways in which I would want to phrase it is principled pragmatism. Principled because you are always coming back to, is this person getting the least restrictive care in the least restrictive environment that they can? If that's the case, then yes, if they're deprived of liberty, the mechanisms need to be in place to put in place to authorise, but that is less concerning. Steve is going to talk about overly restrictive practices a little bit more, but that's where I always come back to. And again, recognising the least worst. What is the least worst thing which can be done here? And if there's been deviation from what the law says is strictly required in terms of authorising deprivation of liberty, how can that be kept firmly under review? So next slide, please, Steve. I then just lastly, from my slot, want to talk a little bit about advanced care planning because it is the cause of such concern at the moment. I really understand why it is the cause of such concern. And it is in part because there's an enormous amount of misunderstanding as to what the law actually requires. So I need to start very briefly with do not resuscitate notices or do not attempt CPR notices. They're technically two slightly different things, but people always quite often use them interchangeably. What they are a decision of a doctor that CPR is either not going to work. In other words, someone's condition is such that you simply couldn't restart their heart if they had a heart attack, say. So it'd be futile. Or it wouldn't be in the interest of the person. It might work. The chances of it working may well be quite low, but actually the impact of the person on CPR would be so awful that the doctors genuinely think it would not be in their interests. Those are two different things. They're two very, very different things. But it's been very important to understand that a DNA CPR notice, a DNA CPR order put in someone's records isn't binding upon the person who's faced with the patient when they've gone into cardiac arrest. It's not saying you are not allowed to carry out CPR. But what the courts have recognised is if someone has a do not resuscitate notice in their records, it's going to play a very significant part in the decision making of the person in the moment of crisis. Which is why the courts have said, and I've given you the references to the two critical court cases there, saying because it's got such a likelihood of impact on the decision making, the person must be involved in the decision. They must be told about it, they must be informed, and they must be consulted. If it simply is on the basis of it's not going to work, they have to be told it's not going to work. They've got the ability to ask for a second opinion, but they don't automatically get a second opinion if it's been a multidisciplinary decision that it's not going to work. But they've got to tell the patient, unless to do so would cause them harm. And if the person doesn't have capacity to participate in the discussion, the law says, it's not guidance, this is the law, the Winspear case, you must involve somebody appropriately interested in their welfare, for instance, a family member. Because that is part of the best interest decision making if you practicable and appropriate and practicable to consult. That's that Winspear case. So next slide, please. If the person's currently got capacity to participate, then advanced care planning involves, as much as anything else, the person identifying what it is that they want. Rachel gave you the overview of advanced decisions to refuse treatment. That is the person saying, if I am in a situation when I do not have capacity to make this decision to accept or refuse this particular medical treatment, I don't want it. There are particular things which have to be complied with for life-sustaining treatment. Writing, witnessed, say, I recognise it's going to apply even in life-sustaining treatment or if my life is at risk. But that's a very clear statement. So can I just please reiterate this by reference to DNA CPR notices? A DNA CPR notice is never an advanced decision on behalf of that person to refuse CPR. They just aren't. And any document which claims to be, that's just not their function. If a person says, I know I don't want CPR, they need to make an advanced decision to refuse that. I would say one really important thing, if you're supporting anyone to make an advanced decision, really, really important to have in that document a statement of values. What's important to you? One of the reasons being, advanced decisions are very powerful but very brittle documents, and there are circumstances under which they might not apply. And if they're not applying, then strictly everyone is into best interest decision making. And at that point, if there's a statement of values, what's important to the person, that means it's much easier to guide best interest decision making by reference to that Aintree test I talked about, putting yourself in the shoes of the person. So that's ADRTs. Advanced statements are either things saying, I don't want something which isn't medical treatment, or it is a statement saying, I would like so-and-so, I would like this sort of treatment, I would like something. It's something which means that it plays a very important role in making best interest decisions, but they aren't binding. And then Rachel touched on the ability to appoint an attorney, someone to make decisions on your behalf. But I won't spend any more time on that now. I just want, last slide, please. I think it's my last slide. No, second last slide, please, Steve. Because the person doesn't have capacity to participate in advanced care planning does not mean it can't be done. It's particularly important in the medical context to avoid the decision being made at 3 a.m. in a panic without knowing anything about the person. And that Winspear case is reiterating that if decisions are going to be made to put into advanced care plans, whatever one calls them, whatever they're labelled, they need to have the participation of people, either the person concerned, identifying their wishes, feelings, beliefs and values. It's really obvious so often what's important to the person, even if they can't formulate something with words which pass, as it were, the capacity test, or others who are important to them. Next slide, please, Steve. I've just given you the example of respect. That is a clinical form which is designed to replace do not resuscitate notices in order to get across the idea of advanced care planning as being personalised recommendations which secure what people actually want or don't want in a holistic way. Is it more important for this person to be kept alive at all costs? Is it more important for this person to be kept comfortable? Respect can be used with someone who does not have capacity. Again, though, it needs to be done in such a way that the person's wishes, feelings, beliefs and values are being properly taken into account. It's been rolled out in different sites, NHS bodies, that's where people can look and see what it's been doing, but it shouldn't be used unless it's been formally rolled out in the area in question. And then next slide, please. I can't emphasize this enough, and I don't think for the people on this webinar this needs any reiterating, but this is a thing you may want to be using depending on where you come from, what sort of support background you've got, what sort of people you're engaging with. This is what the Department of Health and Social Care said at the end of last week as part of the Adult Social Care Action Plan. ACP, Advanced Care Planning, must be done with, not to the person. So that means we can't have blanket care plans, including do not attempt resuscitation orders applied in a blanket fashion. Yes, everybody who might be at risk of losing mental capacity or nearing the end of the life. And also I would say anybody who may not have capacity to make decisions, but is, for instance, at particular risk if they contract COVID-19, decisions should be made. People should think, what should we do? What would be in this person's best interests? But critically, and I've emphasized that last bit, it must always be a personalized process, done with, not to the person. So I think that's me done. And then it's back to Steve, who not only has the slides, he also is now about to come on screen and talk to you all.
There you go. That's a seamless segue, Alex. Thank you very much. And again, it's almost like we planned it, because I'm about to talk about other kinds of blanket policies that have been applied, or we've certainly heard of being applied in the context of the pandemic, which result in overly restrictive approaches to people who may be said to lack capacity. So that's the topic of the next part of the talk. And I'm going to go through essentially a range of different legal provisions, some within but many outside the Mental Capacity Act, which can be used to challenge those kinds of overly restrictive approaches. Say, for example, the decision that everyone in a particular care home must stay in their room and can't even go into the grounds of the home to get some fresh air because it's said that that's in their best interest to remain in their rooms 24/7. So the first point I wanted to flag up that might be used to challenge some of that kind of agenda is within the Mental Capacity Act itself, in the principles that were mentioned. So section 1, subsection 6, looking at a situation where there is a best interest decision to be taken. So we've established that the person lacks capacity. Before that decision is taken or the act is done, we must look at whether the purpose for which it's needed can be effectively achieved in a way that is less restrictive of the person's rights and freedom of action. I think that's quite significant, and it's always important to look at the wording of the legislation, not just the broader intent. Less restrictive of the person's rights and freedom of action. So freedom of action is specifically identified as a core value to which regard has to be had when we're looking for the least restrictive option. So immediately you can see that it may well be that such a blanket policy as I just outlined is inconsistent with that core principle. But then the next place to go, I think, and in this regard, I'm very much channeling the spirit of Mark Neary, Stephen Neary's dad, who was blogged and written so powerfully about rights issues resulting from people being deprived of their liberty or having their freedoms restricted, is Article 8 of the European Convention on Human Rights. And if we're thinking about overly restrictive practice, we're very much in the scope of Article 8 rather than necessarily within the scope of Article 5, the right to liberty, because in order for there to be a deprivation of liberty, there has to be a very significant degree of restriction, as we know from the Cheshire West case. Whereas for Article 8, the way that the article works is that it establishes in 8.1 a right to respect for private and family life. And your private life in the context of Article 8 includes your physical and psychological integrity, your ability to function socially, the way in which you form relationships with other people. So it's a very broad concept, and everyone has the right to respect for those aspects of themselves. And then Article 8.2 says that the state can't interfere with the exercise of those rights unless what they're doing is in accordance with the law. So there has to be a clear basis in law for the interference, and is necessary in a democratic society in the interests of a number of things. And you will see, of course, in that slide includes the protection of health. So yes, there's a legitimate aim there, the protection of health, but is it necessary in a democratic society? And that's now understood to mean, is it a proportionate response? So where public bodies are restricting people, interfering with their ability to exercise their day-to-day lives in the way they choose, that restriction must be proportionate. And there's lots of cases on what proportionality means, but at its essence, proportionality requires a fair balance to be struck between the rights of the individual and any competing interest that's in play. And so that question of fair balance is central to any kind of proportionality analysis under Article 8 or generally. The other important human right to flag under the European Convention is Article 14, the non-discrimination provision. And you can see how it's framed. It's not a human right to non-discrimination. It's a human right to enjoy your other human rights without discrimination. So the enjoyment of the rights and freedoms in the European Convention on Human Rights should be secured without discrimination on any grounds, such as, and then we have this very lengthy list, and it's probably quite revealing that disability is not included on the face of Article 14, given the date in which the convention was passed. But disability is very clearly an other status, and so are specific types of disability or specific levels of impairment. So there cannot be any discrimination on basis of disability in the way in which people enjoy their human rights. So, for example, a policy of a public body that disproportionately affects disabled people can be challenged for a breach of Article 14, as was the case with the challenge that was going to be brought to the guidance that was issued on the lockdown, on how people should behave during the pandemic, and the suggestion in the guidance that people should only leave the home once a day to exercise, a suggestion that wasn't found in law, and which we argued was disproportionate and breached Article 14 amongst other provisions, and has now been changed, as I'll show you shortly. Why do public bodies have to respect Article 8 and Article 14 of the European Convention on Human Rights? Well, because it's our human rights, but more formally, because of Section 6 of the Human Rights Act, which says that it's unlawful for a public authority to act in a way that's incompatible with convention rights. And the caveat in subsection 2 is if primary legislation requires them to act incompatibly, or secondary legislation made under incompatible primary legislation requires such an action, then subsection 6.1 doesn't apply. But that's really quite rare. So in the vast majority of cases where a public authority is allegedly acting incompatibly with a convention right, like Article 8 or Article 14, if that's established, it will be a breach of Section 6 of the Human Rights Act, and therefore it will be unlawful. What's a public authority? Well, often it's quite obvious. So local authorities are public authorities, clinical fishing groups, many other bodies that disabled people and their carers will come into contact with. But there is a particular issue here about private providers of care. Certainly originally, with the House of Lords decision in YL and Birmingham, private care homes were not public authorities for human rights purposes. But that was then reversed by Parliament, and the most recent provision that deals with that reversal is Section 73 of the Care Act 2014, which has not been affected by the Coronavirus Act. And it says that private providers of local authority funded care are public authorities for the purposes of the Human Rights Act. They're what's called hybrid public authorities. So if you are in a care home, for example, funded by a local authority, or if you receive domiciliary care funded by a local authority under the Care Act, the person providing you with that care, the legal person, the company, is a public authority which can be challenged under the Human Rights Act if they interfere unlawfully with your right to respect for your private life, for example, or if they discriminate against you, or if they subject you to inhuman and degrading treatment under Article 3. So they are challengeable in precisely the same way as the standard state bodies would be. And in my view, that must also apply to private providers of care that's funded by the NHS, because otherwise there would be unlawful discrimination contrary to Article 14. Because if you could bring a human rights claim against a care home if you are on the local authority side of the divide, but if your needs get slightly worse and you fall into having a primary health need so that your funding goes to the NHS, you can't bring a human rights claim. Firstly, that's absurd, but secondly, it would discriminate against those people who have primary health needs. So watch this space, but I think that that must be right, that you could also bring a human rights claim against health-funded care providers as well. What about the Convention on the Rights of Persons with Disabilities, the CRPD, the UN Convention? Now, it's not incorporated into English law in the way that the European Convention is through the Human Rights Act, but there are various ways in which the CRPD is legally relevant, one of which is that it's well established that the CRPD rights should inform the interpretation of the European Convention. And so if you have relevant provisions of the CRPD, you can say that when a court's looking at whether there's been a breach of the Human Rights Act, these should and indeed must be taken into account. And I just wanted to flag 3 articles from the CRPD. Article 3, first of all, one of the principles within the CRPD is respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons. And that's obviously going to be very much in play if overly restrictive measures are being put in place. However, Article 11 was mentioned in the most recent judgment on these issues, which we'll come to in a moment, which does require the states to put in place all necessary measures to ensure the protection and safety of persons with disabilities, which is the UN's language, in situations of risk. And clearly the pandemic is a situation of risk. So it is appropriate that there should be, and indeed required, human rights compliance, but there should be all necessary measures in place to ensure protection and safety. But the key word there, of course, is necessary. And we're concerned with the idea of overly restrictive measures, which would not be within the scope of Article 11. The idea that famously Lord Justice Mumby said, what's the use of keeping people safe if you only make them miserable? The balance between risk and autonomy that is at the heart of many of the difficult cases that come up in this area. And Article 17 is a refined version really of Article 8 of the European Convention. Every person with disabilities has a right to respect for his or her physical and mental integrity on an equal basis with others. So well worth citing Article 17 if you're trying to challenge any excessively restrictive or overly restrictive practices. What about the Equality Act? Well, I could spend another hour or so easily on why the Equality Act is relevant here. Obviously, I won't do that because we haven't got that kind of time, but I'm happy to take any questions on Equality Act issues. I just wanted to flag, first of all, the prohibitions on direct discrimination. So you cannot discriminate against someone because of their disability, and direct discrimination cannot be justified on disability grounds. It's not capable of justification. You also can't discriminate against people for something arising in consequence of their disability. So that's where the less favourable treatment results from someone's behaviour, perhaps, or the way that they communicate, or an aspect of their self that is linked to their disability. And discrimination arising from disability can be justified if it's a proportionate means of achieving a legitimate aim. But in relation to the sorts of blanket bans or blanket policies that we're mainly concerned with here, 2 key Equality Act provisions I'd suggest are, first of all, indirect discrimination under Section 19. And that's where a provision or a policy that is neutral, in the sense it applies to everyone or to a large group of people, has a disproportionate adverse effect on a particular group, so here disabled people, in a way that can't be justified. And again, the justification question is is it a proportionate means of achieving a legitimate aim? And if the answer to that is no, then you will have unlawful indirect discrimination. And then also linked very closely, of course, is the duty to make reasonable adjustments. And a failure to make reasonable adjustments is unlawful discrimination. And the duty to make reasonable adjustments will include a duty to make adjustments to policies, criteria, and practices, PCPs, that may put a person at a substantial disadvantage. And the duty then will be to make the adjustments that will be reasonable to remove that disadvantage. So just a few issues or themes to mention to come back to a point that I discussed earlier, and this is directly relevant, I suggest, to the subject of my part of the talk, the lockdown guidance. So under the regulations that were made to protect public health during the pandemic, Regulation 6 of those regulations requires us all to stay at home unless we have a reasonable excuse, and then gives a list, a non-exhaustive list of reasonable excuses, one of which is to leave home to exercise. But the Prime Minister, in his speech announcing these, and the Cabinet Office guidance on what you can and can't do during the outbreak, didn't say you could leave your home to exercise. It said you could leave your home to exercise once a day. And this caused real concern for people with autism, people with mental health problems, who considered that they would be acting unlawfully and potentially get themselves in trouble with the police were they to leave their home more than once a day, but yet, without leaving their home more often, may suffer a real detriment to their mental health or perhaps even their physical health. And so there was great concern about this, and a challenge was then intimated through pre-action correspondence by Byman solicitors, with our colleagues Victoria Butthole and myself acting, and that before we needed to issue the claim, so in the light of the pre-action letter, the guidance was amended, or strictly speaking not amended but added to. So the main guidance, I think, still says we can leave our homes to exercise once a day, but there's a new FAQ which says that if you or a person in your care have a specific health condition that requires you to leave the home to maintain your health, including involving travel beyond your local area, then you can do so. And then an example is given of a learning disability or autism scenario. And so that guidance now better reflects the law and is much less restrictive of the particular needs of disabled people who may require additional access to the outdoors in order to maintain a degree of well-being during the pandemic. And that's a very high-level example, I'd suggest, of the way in which blanket policies can be challenged where they're having a disproportionate adverse effect on disabled people. The only case I think so far that's really grappled with these issues in the context of the pandemic is BP in Surrey, which has had quite a lot of attention. And it's a case in which a care home suspended all visits, and an elderly person, of course, was detrimentally affected by that. And what I think is really important, to pick up a theme of Alex's talk, was that the focus of the Court of Protection inquiry was on whether it was in BP's best interest to stay in the home, because the court could only look at available options, and there was no available option of having visits because the home had decided there would be no visits. And so what the court was asked to look at was, well, is it in BP's best interest to stay in the home? And during the proceedings, it appeared that some creative thought was given. And you see on the slide that he was supported to use Skype and instant messaging. There was to be communication through the window with family members. So was that in his best interest, or was it in his best interest to go and live with his daughter? Those being the two available options. And the court came down very clearly on the side of him staying in the home. But I wonder whether any thought was given to whether there could have instead been judicial review proceedings brought against the home, potentially, as a hybrid public authority for breaching BP's and or his family members' Article 8 rights. Now, I've no idea whether that was considered and rejected or whether it wasn't considered. I'm not in any way speculating about the merits of such a claim in BP's case. I'm merely flagging that if you do want to get an option on the table that isn't there, the only way I'd suggest that you're going to achieve that is through judicial review. The Court of Protection can inquire and it can cajole and it can encourage, but at the end of the day, if the relevant body isn't willing to do the thing that someone's asking for or contending for, that the court can go no further. We know that from the Supreme Court now. And so judicial review is very important as part of the toolkit if you're trying to get another option on the table, including, it might be potentially against private providers of care as a result of the Care Act. And then finally, I think to look at the DOLS guidance and what it says about deprivation of liberty and overly restrictive practices. And so what's suggested in paragraph 16 is that if a DOLS authorization or a court protection order is in place, then decision makers will generally be able to put in place new arrangements to protect that person within the parameters of the authorization or order. But decision makers should avoid putting more restrictive measures in place for a person unless absolutely necessary to prevent harm to that person. And again, to pick up a theme from Alex's talk, DOLS cannot be used if the arrangements are purely to prevent harm to others, because they are about the best interest of the individual. So if the reason for the restrictions is we're really worried that P is going to infect lots of other people in the community, but there's no concern about harm to P, then that is not an issue where there should be regard to the DOLS or the court's order authorising the deprivation of liberty. Any such restrictions in that regard would need to be authorised through the public health powers, and our colleague Neil Allen spoke about those, the webinar last week, which is on the 39 Essex website. Sorry, there was at least one more slide. The right to say goodbye, another very important point. One of the themes of the pandemic so far, people may well appreciate this, is guidance being issued in great haste and then needing to be refined because of evolving concerns about the implications for particular groups or in particular situations. And so I would suggest that's pretty much what's happened here in terms of a recognition that there needs to be a slightly more nuanced approach to visiting in the end of life context. So the latest guidance, I think, in terms of residential care and supported living is that family and friends should be advised not to visit care homes, although no advised there, it's a matter for the individual care home, except next of kin in exceptional circumstances such as end of life. And then obviously there should be precautions in place and alternatives should be explored. And that's then developed again in the social care action plan that was published last week. And just to think again about how are we going to enforce our rights in this context, in this extremely difficult context? Well, thankfully, the administrative court is continuing to function and to operate remotely, as is the Court of Protection, of course. Applications for judicial review can be made and are still being made. Urgent consideration of those applications is still possible. Legal aid is, of course, available for judicial review, but it is means tested, and so many people won't qualify. But of course, unfortunately, a large number of disabled people will qualify on the basis that they don't have any money. So it may be possible for legal aid to fund an application for judicial review. Otherwise, issues like crowdfunding through the Crowd Justice website or otherwise can be explored. And in terms of what the High Court will do on an application for judicial review, it has a wide range of powers, wide range of remedies can be granted, including the power to award damages, although that's very much secondary. The primary remedies being declarations of what the law requires, quashing orders to quash policies or decisions that are unlawful, and in limited situations where there's only one lawful act that can be done, the court can make a mandatory order. And there's the Supreme Court case of N that I mentioned a moment ago to flag up that the Court of Protection can only choose between available options. And so judicial review does need to be considered if the relevant body is adamant that the thing you want to happen will not happen. There we go. I think that takes us on to our question session. So do Alex and Ruth want to come back online? Rachel, sorry, come back online.
Before we do the questions that are in the Q&A, can I just give the people on the phone, we've got 10 people on the phone.
Sure.
And we'll give them an opportunity to ask a question, if that's all right.
That's fine.
So the 10 of you who were on the phone, there are 9 of you now apparently. I'm going to lower your hands, but if any of you want to now ask a question, then if you put your hand up, great. PJ, I'm going to unmute you. I'm going to allow you to talk.
The power.
I know. I've wanted this power for years. Hi, did you want to ask a question? No? Hello?
I don't, thanks, no.
Okay, thank you. Did anybody else want to ask a question who's on the phone before we go to the others that are in the chat? We just wanted to give you a chance. No? Okay. Great.
Okay.
Okay.
Well, Alex and Steve have been remarkably productive in answering questions in typing as they've gone along. So my grand plan to pick up on some interesting questions and pull them back didn't quite work out. There are some questions though that haven't been answered, and there are some questions that have been answered that I thought it might be worth just coming back to. One of them, it was about a question about the fact that some people with conditions like autism might be particularly very stressed at the moment, and due to the changes in their routine. And how do you guard against that stress, which might manifest itself through their behaviour being taken as evidence that they've got some sort of mental health issue that needs addressing? How do you safeguard against that? Alex, you picked up on that already, but I wondered if you just wanted to elaborate, because as you say, that is an extremely important point.
Yes, I mean, it really is, because we know already that people with autism are routinely, as it were, misidentified as being somebody who could be appropriately detained under the Mental Health Act. And once somebody with autism gets detained under the Mental Health Act, we have seen once too often the fact that there then becomes the cycle of it being treated as a situation where the person needs to be in hospital because their behavior is identified as challenging. And then we have a cycle whereas in fact what's going on is this person is manifesting stress and manifesting concern about being somewhere where they're not comfortable with being. And then we have the cycle goes on and on and on, and it becomes more complicated, and it becomes more apparently necessary that the person, for instance, be detained under the Mental Health Act. So we already know that that people need to be alert to recognizing, is this somebody with autism responding to a difficult situation in a way which might be misinterpreted? And it's particularly heightened. So I'm just going to make the situation worse for a minute before I then try and make it slightly better. It is heightened at the moment by the fact that there are quite a lot of people, clinicians, for instance, who will be working outside the area with which they are comfortable, because people are being redeployed all over the place. So you might have somebody who wouldn't necessarily be from a specialist team who might be able to go, well, actually, I recognize what's going on is X, Y, and Z, in particular, that this is a person with autism responding to situational challenges. So what I flagged up on when I was frantically answering emails, or not emails, answering questions, was that there's some quite useful guidance from NHS England for clinicians about how do you respond, essentially educating clinicians in autism and learning disability if you are not familiar with it. And one of the things it does is give some assistance in thinking through, am I really actually, as it were, correctly identifying this as somebody whom I might need to be thinking about? You can find that guidance. I now can't find it scrolling through, but you can find it on my resources page on the my website, which actually, Steve, do you mind just flicking to the next slide just so I can show you? It's the one which has mentalcapacitylaw&policy.org.uk. There's a resources page I've done on COVID-19 and the MCA, and I put various things, and one of the things includes that guidance I've just been mentioning. Steve, was there anything you wanted to add on that point?
I think you've covered everything, Alex. Thank you. I would just plug your resources page. It's an incredibly helpful resource. So do please take a look there, everyone.
Great.
Rachel, are you going to Question Master still?
Sure. A few questions sort of linked theme, although not quite the same question, but a few people have raised questions about reporting recording decisions, and what level of recording needs to be taking place, given the constraints that everybody's operating under. I just wondered if either of you can pick up on that.
Well, yeah, I'll have a quick go at that, and I'll borrow Alex's concept of I've forgotten the exact term, Alex, but essentially appropriate and proportionate levels of recording. You had a nice buzz phrase earlier. Can you remind me?
It was principled pragmatism.
Thank
was my
you. I like that
phrase.
I like that very much. And I think one of the, I'll riff on it as well, because one of the principles that you'd want is human rights compliance, of course. And anything, all of the qualified rights where there's a proportionality inquiry as to whether something's proportionate requires the person who's alleged to have done the breach to justify themselves. And that means you need some kind of record, because otherwise you're potentially in a lot of trouble if you're challenged, if you can't explain why you've done the things that you've done. So it needs to be proportionate itself, and there needs to be appropriate recording in the circumstances. But anyone who ever advises public bodies or providers will say, look, you need to show your workings to an extent. You need to have some reasoning, otherwise any challenge is likely to cause you trouble. So I mean, apart from not just in the defensive sense, of course, reasoned decisions are better decisions as well. So I would say very strongly that we shouldn't use the pandemic to throw out of the window general good practice in terms of human rights compliance or other legal compliance. There needs to be an appropriate degree of recording.
Yeah. Alex, did you want to?
No, I think Steve said it all. Yeah, thank you.
There have also been a couple of questions in relation to carrying out assessments, which is something that I know is on a lot of people's minds at the moment. Alex and I did a webinar about this last week as well. There are questions about how assessments can be carried out and what we would do. So Alex, would you like to reprise your starring answers to those questions?
Well, I think I might direct people gently to the recording of the webinar we did last week, actually, which you can find on the top page, or top link on that page there. You can find on our Chambers resources page. I think, again, if I'm a great fan of coming up with slightly naff buzzwords, but it's least worst. You are identifying that what you want to be doing in terms of assessment. People know what they're meant to be doing. I'm assuming everyone here, I'm going to take it on trust that everyone here knows, because you've logged into this, that you know what you should be doing. And you recognize there's something that's getting in your way. And you are identifying, is there something I can do to get around that problem? Well, if there is, fine. If there isn't, then how is it that you can try and make a workaround? And I think the one thing I would emphasize is when one actually goes back and looks really in detail at the Mental Capacity Act, I'm an enormous nerd, so I spend far too long looking in detail at the Act. What it reminds us is capacity assessment in particular is it's a balance of probabilities. It's not perfection. It's not the criminal standard beyond reasonable doubt. It is balance of probabilities. Is it more likely than not that this person lacks capacity? And so much of it also is about a reasonable belief. Why do you reasonably believe this person doesn't have capacity? And then again, on best interests, and assessments would also go to best interests. Why do you reasonably believe that what you're doing is in the person's best interest? So I should say I'm phrasing as if I'm talking to people who are carrying out capacity assessments and best interest assessments, because that's really who I'm trying to direct my message to. And when reasonable belief, and the courts have emphasized this, means explaining why it is that you've reached the conclusion that you've reached. In fact, I was recording something for my students at King's College London earlier on answering exam questions. And it's exactly the same thing. You don't just show the answer. You don't just say, it's in someone's best interest because this person lacks capacity. You have to be able to say they don't have capacity because X, Y, and Z. It's showing your workings, which is just as important now, and if not more important, because you're having to show complex workings sometimes to say, I've had to try all this stuff, it hasn't worked. I recognize we're in this imperfect situation. That was all of the webinar from my bit of the webinar from last week in about 5 minutes.
Very, very concisely done. We've got some questions about advocacy as well, which I think I could just pick up that we've covered that as well, partly last week in the webinar and partly in a sort of further frequently asked questions session that we did earlier this morning that should be up live. The specific question we've had about advocacy. Here I'll just read out, which is, with regard to someone with a learning disability, it's just disappeared on my screen. There we go. Having an advocate or carer, advocate going into hospital and staying with them. Hospitals are saying in the main no one can go in with them. Parents deciding not to send people to hospital, taking their chances at home. Any thoughts or advice? I think the starting point is probably that the advocacy obligations remain unchanged by the Coronavirus Act. So if it's something that should have been allowed before, it should still be now, but obviously there may be practical issues with hospitals. Steve, I don't know if you have any thoughts on that situation.
Quite a lot to say about that. I'll try and be as succinct as Alex managed to be. First thing to flag is that the Department for Health Social Care did issue new guidance, I think it was DHSC, that said that visits may be appropriate where a person would experience distress if they were not allowed to have someone accompany them to hospital or to visit them, in particular reference to people with learning disability. I would suggest that is merely exemplifying the reasonable adjustments duty. I find that guidance to be entirely unsurprising and almost disappointing that it's needed, frankly, because it's so obvious, isn't it, that you cannot just exclude everyone from hospital. When you think about the needs of some severely disabled people, how traumatizing and horrific it would be for them to be taken to hospital on their own, it's just blindingly obvious that it's going to be reasonable to have a very carefully managed visit from perhaps one family member who's very close to them, friend who's very close to them, or indeed to have that person come and support the person in hospital more substantively as well. So very concerning that these exclusions are being applied in such a blanket basis, not to in any way undermine the obvious need to protect public health, and bringing people to hospital potentially increases the spread of coronavirus. So, again, a statement of the blindingly obvious. But what troubles me is the leap to blanket rules and exclusion without apparently any pause to think about, well, do we need an exception to this? And I understand, again, in messaging terms, why as soon as you start allowing exceptions, that suggests you're undermining the whole thing. But actually, I don't think it does. I think very, very carefully crafted exceptions and recognition of very particular different needs is a good thing and has general public support, and it's what the law requires. If people are not going to hospital because they're so concerned about what's going to happen to them there, or the way they'll be treated, or the way their family might be excluded, we've got a major problem. Society has a major problem. And that potentially infringes Article 2 of the European Convention on Human Rights, the right to life. So people who are in that situation, I would suggest, need urgent legal advice. If they really have good grounds to think that if they go to hospital they won't get treated, or they'll be discriminated against, or they won't be allowed to have necessary visits or support, they will need to get advice about challenging that and not just wait at home, because that's obviously hugely detrimental to people's health. So I hope that's relatively rare. And we should stress as well that although there's a lot of concern about the pressure on the NHS and the risk of demand for treatment outstripping supply, it's extremely clear that that hasn't happened yet. There's no suggestion that any NHS body or area is above capacity at the moment. So there's no resource allocation problem solved, thankfully, yet. And therefore people should be getting treated if it's in their clinical best interest. And that treatment should be adjusted to meet their individual needs.
Great. Alex, anything to add? Or?
No, I think Steve said everything.
Yeah. Steve, I can see, coincidentally, I've just been looking and it's popped up on my screen. You've flagged that you're going to.
I flagged one, didn't I? Yeah, rather like. I take
so
that.
Do you want to take that one?
Well,
nice and easy.
Asking you to ask me a particular question, Rachel. Sorry. Follows them directly from the talk, because it's actually two restrictive practice questions. The first being people who are not allowed out in gardens or into communal areas within care homes. Is that going to be disproportionate? And I think the answer to that is, of course, as with everything in this area, it depends on the particular facts and reasons, but it's likely to be a disproportionate interference with various of their rights under the Human Rights Act and the Equality Act. there would have to be a justification, an objective justification for why such an intense restriction is going to be needed. And I don't even really need to think about whether that engages Article 5 and the right to liberty, because the answer to all of this, I think, is in Article 8. And the balancing exercise that obviously needs to be carried out can and must be carried out under Article 8. So that's the way I would be going into those kinds of questions. The link question is, if there's already a blanket policy of saying no resuscitation, blanket DMAR, what can be done about it? Get legal advice now, because it's crystal clear, and we've seen some of the guidance already, that those decisions must be taken on an individual basis, and any blanket approach is going to be unlawful. So of course we can't cross the line ourselves today to move away from training and general discussion to advice, but what we can say is get advice and don't allow that, pursue it. And a number of bodies will be very interested in that, I'm sure, including but not limited to the Equality and Human Rights Commission.
Alex, I don't know if you can still hear me. You're on mute, I think.
Yes. So I was just frantically typing something to somebody, so I didn't want to hear the clack of little fingers in the background. So I'm slowly learning Zoom in this new environment.
Cracking job.
I spent most of yesterday realising people could see my writing. We've had a question in relation to if somebody lacks capacity and is living at home with family and they're now shielding. I assume that's the whole family. Is it appropriate to make reference to that in terms of restriction of their liberties in care plans and risk assessments and things, which I think probably feeds or comes out of the question you were answering earlier in terms of recording?
Yes, that's a really important question, actually. It depends on, I mean, I can't give advice. Sorry, I mean, Steve and Rachel and I say this ad nauseum. We're not allowed to give advice on the facts of individual cases. But at a kind of the abstract level, if what is going on to ensure that the person is shielded means that they are being stopped by somebody, family member, informal carer, professional carer, from leaving where they live, and if they're under supervision and control, continuous supervision and control at that place, and they can't consent to it, then they're deprived of their liberty. And at that point, yes, deprivation of liberty stuff does arise. And if it's a supported living place or own home, that couldn't be authorized by DOLS. That would have to be done by way of an application to the Court of Protection. I'm not going to say that you can't say that every single shielding situation gives rise to a deprivation of liberty, but so it's going to be a question of thinking in each case, what would actually be done if this person tried to leave their home? Because if they tried to leave their home and they were stopped and then there was supervision, that's when we start thinking about deprivation of liberty. I would certainly, in terms of good practice and in terms of making sure that we adopt this principle pragmatism approach, if there's care planning being done, I would identify that there's shielding, and I'd identify the steps which are being done to ensure that that shielding is effective. And then I would be thinking, does that cross the line from a restriction on that person's liberty to a deprivation of their liberty? There's some more guidance about this, because this is not an entirely straightforward issue. There's some more guidance about this on that top link there, the resources bit. There's a guidance note, a rapid response guidance notes we did what feels like months ago now, but I think it was about 2 weeks ago. A rapid response guidance note on social distancing and capacity, which starts thinking about that.
We're actually getting through these questions at quite a pace. There's a question in relation to, is it right that suspending capacity assessments on the grounds that face-to-face assessments might not be achievable isn't really acceptable? My own feeling would be, yes, there are probably ways to work around that. But Steve, I wondered if you wanted to address that from sort of Quality Act perspective.
I think I can give a slightly different, although entirely complementary perspective than the one Alex gave earlier. When you think about it through an Equality Act lens, absolutely, you need to make adjustments to your usual practices. and recognise that the best can't be the enemy of the good enough. And how can it be better to just not assess capacity than to do it imperfectly? It doesn't make any sense to me, and unsurprisingly, therefore, that's not what I think the law requires. So people have to do their best. I'm going to draw an analogy with a related area, which is in terms of special educational needs provision. The duty to secure the provision that children and young people with education, health and care plans remains in force. And local authorities understandably say, well, how are we going to do that? The schools are closed, or many of them are closed, at least in large part. Well, the answer is you be creative. You try and find creative ways in which therapies or other provisions can be made in the person's home or otherwise. You can use technology to deliver remote sessions to the extent possible. Maybe some things that are impossible, of course. You don't do those, but you do the best with what you can. And I think there's no magic in capacity assessment. It's precisely the same. You do it the best you can. You make the adjustments that are likely to achieve the best result and involve PEAG to the greatest possible extent.
Can I just come in there as well? The question there also, I completely agree with everything you've just said, Steve. The question there asked quite an interesting supplementary point, which is effectively about proxy assessment. So in other words, could you make a best interest decision that you should video record somebody else who actually is in the place? So for instance, in hospital, you can't get a social worker going into hospital at the moment. In many situations, it's extremely inadvisable. So could you get the social worker who's supposed to be carrying out, for instance, the best interest assessment or capacity assessment, say for DOLS purposes, could you get them to give the questions to somebody to then ask and then video record the exchange, and as the person there identifies, capture body language as much as verbal responses? In principle, I can't see any reason why you couldn't. I could see that being very interesting. I could see that being a very creative way around. Can I just flag up one quite substantial issue, though? I mean, over and above kind of data protection, GDPR, recording consent, there's that issue. There is also the issue that the person who ultimately is required to come to the determination, does this person have or lack capacity? If they're having to do it by proxy, they are actually having to do this at arm's length. So they wouldn't have the ability to respond to the way in which, for instance, the person under assessment was answering the questions. So it's quite a rigid thing to do. You're sending someone with a set of questions, hoping they ask them correctly, and hoping that they got the answers, as it were, recorded correctly, either by video or by writing. I can see the logic. It certainly falls into on the zone of what might be the least worst option. This could certainly be somewhere, but I want quite a clear documentation for myself as to why that approach had been undertaken. And that also links, actually, I think somebody also asked about the decision maker. Yeah. So my understanding is that decision maker is the person to assess capacity for a specific decision. SLT therapist should assess the person's capacity to comply with SLT recommendations. In the absence of an SLT due to staffing, is a doctor able to decide if the person lacks capacity to make this decision? It goes back to this idea of who is the decision maker here? What information do they have upon which they can sensibly say that this person has or lacks capacity to make the decision? And they will be drawing on multiple different sources. There's nothing wrong in principle there with saying that the doctor couldn't be carrying out the thinking behind the assessment, but it would be for the whoever is in charge of drawing up the SLT recommendations to go, well, am I comfortable that the evidence I've been given by this doctor actually satisfies me that this person has or lacks capacity? Can I just for 1 second hook onto that? The question of who is the decision maker in any given context can be ferociously difficult. We find it so ferociously difficult in Chambers that we've dedicated quite a lot of space to it. Sorry, the person saying what's SLT, speech and language therapist. Sorry, we've slipped into acronyms here. In terms of decision making, we devoted quite a bit of space to it in the guidance note we did about, actually, in fact, best interest decisions, which you can find on the mental capacity, on the first link there. I would also just add that if and when, it's not a question of when, but it's not a question of if, it is when, the Mental Capacity Act Code of Practice is revised. It's underway at the moment. It's been slowed down enormously because of the pandemic, but I'm one of the people revising it. One of the things that there's going to be an awful lot more detail in there is how you think about who is the decision maker. Because the Mental Capacity Act, Rachel's overview gave you this idea that in most cases, there is no one formal decision maker. Unless someone's got a power of attorney, unless there's a deputy, or unless they've made a decision in advance. In every other situation, it's meant to be collaborative thinking. But obviously that leads to problems with accountability. And so how you hold the ring between informality and accountability is a difficult issue. We've discussed it in our capacity guide and our best interest guide. So I suggest people who need to think about it professionally have a look at that.
Great. I think we're coming up towards the end of our time. Steve, had you just flagged another question, or was I?
I thought it was a question that was asked very early on in the talk, and it's an extremely good one. Can blanket bans be challenged in relation to people detained under the Mental Health Act? Yes, they can, but don't try and challenge them in the tribunal, because the tribunal only has jurisdiction to consider whether or not the person should remain liable to detention under Section 2 or 3, general terms. You will need again to bring, or at least contemplate, judicial review if a hospital has decided that they will cancel all leave, for example, or if there's an absolute ban on any patients going into the grounds. All of those things will potentially infringe the various provisions that I talked about in my talk under the Human Rights Act, the Equality Act, and so on. And the policy will need to be justified, or else it will be unlawful. And people who are detained under the Mental Health Act have exactly the same right to bring a judicial review as anybody else does. So it's really important, I think, that because it's such a specialist area, lawyers often really specialise in the Mental Health Act, that people don't lose sight of the broader public law principles as well, and the opportunities to bring judicial review challenges, rather than simply just appealing to the tribunal, which is the standard forum for deciding issues under the Mental Health Act.
Absolutely. We just had a question pop up in sort of general terms about whether it's still appropriate to be making Section 21A challenges. I don't know if either of you want to.
Yes, I'll take that briefly, and that probably maybe have to be our last question, I think. Yes, so those of you, Section 21A is the ability to challenge a DOLS authorization before the Court of Protection. Absolutely, yes. It really is appropriate to make the challenge. And the question is it still appropriate even if the solicitors are unable to visit the person objecting? Well, yes, absolutely. If there's reason to think, following the case of RD, that the person themselves wants to bring the challenge, or it's in their best interests for the challenge to be brought, because if they could make the decision themselves to challenge, they would make it. It's really important. They have an absolute right to have their case heard before the Court of Protection. And when the case is before the Court of Protection, it is for the state to justify why that deprivation of liberty is necessary and proportionate. One's going to have to get very creative as to how it is that the information can be put before the court, and how it is that the solicitor, for instance, can be enabled to make the arguments on behalf of the person that needs to be made. But the mere fact that the solicitor couldn't, for instance, step foot in the care home is absolutely not a reason not to bring a Section 21A challenge. And in fact, I think Section 21A challenges are almost more important at the moment than they normally, well, they're always important, but they're incredibly important at the moment, while we're still at one level trying to calibrate, because people are still doing an awful lot of calibration here between how do we react to the public health emergency, but how do we make sure we then go completely overboard and have situations where individuals are being deprived of their liberty unnecessarily.
Great, thank you. Shall I hand back to Sam then?
Yes, thank you, Rachel. Anybody would think we had rehearsed that. I had literally just unmuted myself. So thank you, all three of you again. We've had at least one person in the chat say thank you very much. They had to leave us, but they were very grateful. I have found it fascinating, and I'm sure lots of others have. As soon as we get the recording together, we'll put it on our website and we'll put it on social media, and we'll directly email you all who came as attendees. So yeah, thank you, the three of you again, and yeah, hopefully it's been very useful to everybody.
Brilliant. Thank you so much.